Contract reviews are a critical safeguard in business relationships. A thorough review process can prevent costly disputes, protect your interests, and ensure clarity in business agreements. Today, we're exploring the essential steps in the contract review process that every business professional should know. A robust contract review serves multiple purposes. It mitigates risk, ensures all parties understand their obligations, and protects your or your client's interests. Before signing any agreement, certain key elements deserve special attention. Following a systematic contract review checklist is the foundation of effective review. This includes properly identifying all parties, ensuring all terms are clearly defined, and verifying that signature blocks are included. Your checklist should also cover whether all referenced exhibits and schedules are attached, and that all mathematical formulations are accurate. The checklist should extend to verifying term expiration details, early termination instructions, and the rights of all parties. Performance obligations and payment terms must be precise, while reimbursable expenses should be clearly outlined. Warranties, representations, and confidentiality provisions need careful scrutiny. One crucial aspect of contract review is ensuring your client can exit the agreement if necessary. Most parties only revisit a contract when they want to assign it or terminate it. That's why termination clauses are among the most important sections to review. Pay close attention to renewal terms. Watch for what are sometimes called forever contracts, with automatic renewals that continue unless notice is given within a specific time frame. While auto renewals can be convenient when relationships are positive, clients should always have a clear path to exit if they're dissatisfied. Termination provisions should allow clients to end the contract if they're unhappy with performance or in the event of a breach. Look for reasonable cure periods, the time a party must wait before canceling after a breach occurs. Assignment clauses deserve special attention. Ensure the contract allows assignment without requiring consent from the other party in cases of corporate reorganization. This simple provision can save significant time and resources later. Indemnification terms should generally be mutual. If you notice only one party is indemnifying the other, either remove the clause or modify it to be reciprocal, even in situations where one party seems unlikely to cause liability. Collection expenses should be the responsibility of the non-paying party. This creates an incentive for timely payment and helps avoid collection actions. Confidentiality and non-disclosure provisions protect sensitive business information. These clauses should clearly define what constitutes confidential information, how long the obligation lasts, any permitted disclosures, and remedies for breaches. Ensure these terms are practical to enforce and continue beyond termination when appropriate. Limitation of liability clauses cap financial exposure in disputes. These should be reasonable in scope and amount, tailored to the specific contract, and clear about exclusions like gross negligence or fraud. Verify whether the cap includes or excludes consequential damages and aligns with risk tolerance levels. Governing law and dispute resolution terms specify which jurisdictions laws apply and how conflicts will be handled. Choose a familiar jurisdiction to reduce complexity and costs. Review whether disputes will be resolved through litigation, arbitration, or mediation, and ensure the designated form isn't unreasonably inconvenient for your client. For service contracts, service-level agreements outline performance standards. Review uptime guarantees, response times, penalties for unmet standards, and escalation procedures. Ensure all metrics are measurable. Vague terms like reasonable effort often lead to disputes. Modern contract review can be enhanced with technology. AI-powered software can flag risks, compare clauses against standards, and provide customizable checklists. These tools offer version control, collaboration features, and integration with document management systems. While technology improves efficiency, human legal judgment remains essential. Certain situations warrant involving a specialized contract review lawyer. These include high-value transactions, cross-border agreements, intellectual property matters, complex indemnity terms, and regulatory compliance issues. Legal experts can negotiate better terms, assess risks, and ensure enforceability. A methodical contract review process is your best protection against unfavorable terms and future disputes. By carefully examining key clauses, understanding risk areas, and leveraging appropriate tools and expertise, you can ensure agreements truly serve their intended purpose, providing clarity and protection for all parties involved.